Before we begin, a quick and important disclaimer. The information provided in this presentation is for general informational and educational purposes only. It is not legal advice. I am not an attorney, and watching this video does not create an attorney-client relationship. The law is incredibly complex and differs significantly between states and jurisdictions. For advice on your specific situation, you must consult with a qualified, licensed attorney in your area. Imagine this. You're driving home after a long day. It's dark, you're tired, and you're thinking about what's for dinner. Suddenly, your entire world is flooded with red and blue light. Flashing lights in the rearview mirror. Your heart hammers against your ribs. Your hands get slick on the steering wheel. You pull over, your mind racing. What did I do? Was I speeding? Is my tail light out? An officer approaches your window, flashlight beam cutting through the darkness. You've seen this scene 1,000 times on TV. You think you know the rules. You think you know your rights. But what you think you know is about to become the most dangerous thing in your life. The gap between what Hollywood shows you about the American legal system and how it actually works is a canyon. And falling into that canyon can cost you your money, your reputation, your job, and even your freedom. The myths and misconceptions we've all absorbed from movies and crime dramas aren't just harmless trivia. They are traps. They are dangerous misunderstandings that can turn a simple traffic ticket into a felony investigation, or a casual conversation into a confession. That's why we're here today. We are going to expose and dismantle the top 5 most dangerous misconceptions about criminal law in the USA. This isn't about legal theory. This is about practical, real-world knowledge that can protect you and your family. Understanding these truths could be the single most important thing that stands between you and a life-altering legal catastrophe. So let's get straight into it. The first, and arguably the most pervasive myth of them all, is misconception number 1. The police have to read you your Miranda rights the moment they arrest you. You know the scene. It's burned into our collective consciousness. The determined detective slaps the handcuffs on the suspect, shoves them against the hood of the patrol car, and begins the famous speech. You have the right to remain silent. Anything you say can, and will be used against you in a court of law. You have the right to an attorney. We've heard it so many times we can recite it from memory. And because we've seen it 1,000 times, we assume it's a legal requirement tied to the act of arrest itself. We believe that if an officer puts you in cuffs and doesn't read you that script, they've made a fatal error. The case will be thrown out, the arrest is invalid, and you get to walk free. That belief is completely, utterly, and dangerously false. The reality is, the police are not required to read you Miranda rights when they arrest you. They are not required to read them to you when they put you in the back of their car. They aren't even required to read them to you back at the station. The requirement for a Miranda warning has a very specific trigger that has nothing to do with the physical act of an arrest. The rights only need to be read to you before a custodial interrogation. That's the magic phrase. Custodial interrogation. It has 2 parts, and both must be true for Miranda to apply. Let's break that down because your freedom could one day depend on you understanding this. First, custodial. This means you are in custody, but custody is a legal term of art. It doesn't just mean you're in handcuffs or in a jail cell. The legal test is whether a reasonable person in your situation would feel that they are not free to leave. So, could you be in custody for Miranda purposes while sitting in your own living room? Absolutely. If 4 officers are in your house blocking the exits and telling you to stay put while they search, a reasonable person would not feel free to just get up and walk away. That's custody. Conversely, you could be at the police station, sitting in an interview room, and not be in custody if you came there voluntarily and the police have made it clear you are free to leave at any time. The location is less important than the circumstances of the confinement. Second, interrogation. This is the other crucial piece. An interrogation isn't just a police officer firing questions at you under a hot lamp. The legal definition is much broader. It includes any direct questioning about the crime, of course, but it also includes what's called the functional equivalent of a question. This means any words or actions on the part of the police that they should know are reasonably likely to elicit an incriminating response from you. For example, 2 officers are driving you to the station. You haven't been read your rights. One officer turns to the other and says, "Man, it's a real shame about that little girl. The family is so worried. I just hope we find her before it's too late." They aren't talking to you, but they know you can hear them, and they know that statement is designed to make you feel guilty and start talking. That is the functional equivalent of an interrogation. So both conditions have to be met. You must be in custody, and you must be subject to interrogation. Only then are the police required to read you your Miranda rights. Now, why is this misunderstanding so incredibly dangerous? Because people make the fatal mistake of talking before the magic words are said. Let's go back to our traffic stop. The officer asks you to step out of the car. You're standing on the side of the road. You are not free to leave. This is called a detention, and it can be a gray area. But let's say for argument's sake it doesn't yet rise to the level of custody for Miranda purposes. The officer asks you, "So where are you coming from tonight?" You thinking you're being cooperative and knowing you haven't been arrested or read your rights start talking. "Oh, I was just at my buddy's place watching the game. I only had a couple of beers over a few hours. I feel totally fine." You just confessed. You just handed the officer the core evidence needed for a DUI charge. You were not in a formal custodial interrogation, so no Miranda warning was required. Everything you just said is admissible evidence that will be used to convict you. People voluntarily give up their right to remain silent every single day, because they're waiting for a formal invitation to shut up that never comes. They think they have a freebie conversation before the real interrogation begins. There is no such thing as a freebie conversation with the police. Furthermore, let's say the police do mess up. Let's say they arrest you, put you in an interrogation room, and start questioning you about a crime without reading you your rights. And you confess. What happens then? Does the case get thrown out? Almost never. The consequence is not that the entire case is dismissed. The consequence is that the statement you gave during that unmirandized custodial interrogation will likely be suppressed, meaning the prosecutor can't use it as evidence in their main case against you. But any other evidence they have? That's still fair game. If they found the stolen goods in your trunk before they ever talked to you, your case is still going forward. Even worse, if you make a statement, and that illegal statement leads them to new evidence, that new evidence might still be admissible against you under a complex legal doctrine known as the fruit of the poisonous tree. The rules are complicated with many exceptions, and you can't rely on a police mistake to save you. So what is the single most important takeaway from this? It's this: your rights are not a gift given to you by the police. They are yours from the very beginning. You don't have to wait for them to tell you that you have the right to remain silent. You have it the moment you see those flashing lights. The most powerful words in any police encounter are not the ones they say to you, but the ones you say to them. And those words are simple, polite, and firm. "Officer, I am invoking my right to remain silent. I want a lawyer." You say that, and then you do exactly that. You remain silent. You don't try to explain. You don't try to be helpful. You don't try to talk your way out of it. You have asserted your constitutional rights. And now the conversation is over. Understanding this one fundamental truth, that Miranda is not a switch that gets flipped upon arrest, is the first and most critical step in protecting yourself from a system that you do not understand as well as you think you do. And we're just getting started. The next misconception is one that gets innocent people to plead guilty every single day. Let's unpack misconception number 2. The police can't lie to you during an interrogation. This is, without a doubt, one of the most dangerous and damaging myths in the entire American legal system. Not only is it false, it's the complete opposite of the truth. Police officers are not only allowed to lie to you, they are trained to lie. It is a legally sanctioned, court-approved, and highly effective interrogation technique, used every single day in every precinct across the country. Understanding this will fundamentally change how you view any interaction with law enforcement. Let's imagine a scenario. Let's call our guy Greg. Greg is a decent guy, works a 9 to 5, has never been in trouble. One evening, he's driving home and gets into a minor fender bender. No one is hurt, but the police are called to file a report. As the officers are talking to the other driver, they find a small bag of illegal drugs tucked under the passenger seat of the other car. Now they have a problem. 2 people, 1 bag of drugs. Who does it belong to? The other driver immediately points the finger at Greg. "I've never seen that before. He must have thrown it in my car after the crash." It's a ridiculous claim, but it's enough to create suspicion. So the officers separate them and take Greg to an interrogation room at the station. Greg isn't under arrest, he's just helping with their investigation. He's nervous, but he's not scared because he knows he's innocent. He thinks, "I'll just tell the truth, explain what happened, and I'll be home in an hour." The detective comes in. He's friendly, offers Greg a coffee. He small talks for a few minutes, building a false sense of rapport. Then he leans in and says, "Look, Greg, I'm gonna be straight with you. Your buddy in the other car, he just confessed. The whole thing. He said the drugs were yours, that you panicked after the crash and tried to hide them in his car. He's already signed a statement. The DA is giving him a deal to testify against you. Right now he's walking out of here and you're the one holding the bag, literally. We're looking at a felony possession with intent to distribute charge here. That's serious time. Years. Everything the detective just said is a complete 100% fabrication. The other driver hasn't confessed. There is no deal. There is no signed statement. But Greg doesn't know that. In Greg's mind, the world has just collapsed. He's trapped. His mind is racing. How could he lie about me like that? They have a signed statement. A jury will believe that. I'm going to prison for something I didn't do. The detective sees the panic in his eyes and offers him a lifeline. A fake one. But, the detective says, I think he's lying. I think you're a good guy who just made a mistake. If you work with me, I can help you. Maybe we can get this down to a simple possession, a misdemeanor. You'll probably just get probation, no jail time. But you have to be honest with me. Just tell me the drugs were yours for personal use, and we can make all this felony stuff go away. This is the moment where innocent people confess. Greg is now faced with a choice, but it's a false choice. In his mind, it's option A. Maintain your innocence, be called a liar, get charged with a major felony based on your friend's confession, and risk a decade in prison. Or option B. Tell a small lie to save yourself, admit to a lesser crime you didn't commit, and get to go home with just probation. What do you think most people choose when they're scared, exhausted, and completely ignorant of the law? They choose option B. They sign the confession. And just like that, the case is closed. The police get their conviction. And an innocent person now has a criminal record. This isn't just a wild hypothetical. This strategy, known as deceptive interrogation, was given the green light by the Supreme Court in the 1969 case Frazier v. Cupp. The court ruled that police deception is permissible as long as it doesn't shock the conscience or overcome the suspect's will to resist. That sounds protective, but what does it actually mean? The bar for what shocks the conscience is incredibly high. It generally means things like physical violence, threats of harm, or denying someone food, water, or sleep for extreme periods. But lying? Lying is a-okay. They can lie about evidence. They can say they found your fingerprints on the murder weapon when they didn't. They can say they have 5 witnesses who saw you do it, even if they have none. They can say they have satellite footage of you at the scene of the crime. They can and do lie about what your co-defendants have said. This is the real-life version of good cop, bad cop. It's not just a TV trope. It's a calculated psychological strategy. The bad cop presents you with a terrifying false reality where you're facing maximum prison time. Then the good cop comes in and offers you a seemingly reasonable, but equally false way out. They are manufacturing a crisis and then selling you a solution. The solution is always to confess. Once you confess, it is almost impossible to take it back. Think about it. If your case goes to trial and you stand up and say, "The police lied to me, I was scared, the confession is false," who is the jury going to believe? A detective with a badge and a distinguished career? Or a defendant who has every reason to lie to save their own skin? Your own words, captured on video, become the most powerful weapon against you. You become the star witness for the prosecution. This is why the single most important advice I, or any competent defense attorney, can give you is to never ever speak to the police without a lawyer present. Your silence cannot be used against you. Your demand for a lawyer cannot be used against you. But every single word you say can and will be. When you say, "I want a lawyer," the game changes. The police are legally required to stop the interrogation. They can't lie to your lawyer about the evidence. Your lawyer knows their tactics. Your lawyer understands the law. Your lawyer acts as a shield, protecting you from the psychological warfare that you are simply not equipped to handle on your own. You cannot outsmart a system that is designed from the ground up to make you incriminate yourself. You can only refuse to play the game. So we've established that you can't talk your way out of trouble, and that the police can and will lie to get a confession. But what if you follow this advice, stay silent, and get arrested anyway? What happens next is a minefield of new misconceptions, and the next one we're going to tackle is about that one phone call that TV and movies have told you is your absolute right, your lifeline to salvation. The truth is that one phone call, if you use it the wrong way, can be the very thing that destroys your entire case. So let's break down misconception number 3, the right to one phone call. On screen, it's the moment of hope. The hero is in cuffs, slumped on a bench in a precinct, the world crashing down around him. The grizzled detective slides a phone across the table and grunts. You get one call. And that call is always to the one person who can fix everything. It's a dramatic, pivotal moment. It's also, for the most part, a complete fantasy. And believing in that fantasy can land you in a world of hurt. First, let's get the biggest shocker out of the way. There is no federally guaranteed, constitutional right to a phone call upon arrest. It's not in the Bill of Rights. It's not part of your Miranda rights. The Supreme Court has never said, every person arrested in the United States gets one phone call. It just doesn't exist at that level. So where does this idea even come from? It comes from a patchwork of state laws. Most states have passed statutes that do grant a person in custody the right to make a call, but the rules are wildly different from one state to the next. In California, for example, the law says an arrested person has the right to make at least 3 completed phone calls immediately upon being booked, and no later than 3 hours after arrest. 3 calls, not 1. In other states, it might be a reasonable number of calls. Some states specify you can call a lawyer and a family member. Others might include a bail bondsman. Some states have no specific law on the books at all, and it's just policy, which can be even more flexible. So the idea of one call is already wrong. But that's not the dangerous part. The dangerous part isn't about the number of calls you get. The danger is what you do with them. Because that phone on the detective's desk, or the one bolted to the wall in the holding cell, is not your lifeline. It is a microphone. It is a recording device. It is an evidence-gathering machine designed to be used against you. Every single call you make from a police station or a jail, with one critical exception we'll get to in a moment, is recorded. All of it. They often play a quick, automated message beforehand saying, this call may be monitored and recorded. But when you're in a state of panic, your heart pounding, your mind racing, that warning just becomes background noise. You don't hear it. You don't process it. You just want to talk to someone familiar. And that's the trap. Let me paint you a picture. Let's call him Alex. Alex is 22 years old. He gets pulled over after a party. The officer smells alcohol, conducts a field sobriety test, and arrests him for a DUI. Alex has never been in trouble before. He's terrified. He's sitting in a holding cell, and the officer says he can make a call. Who does he call? Not a lawyer. He doesn't know any. He calls his best friend, Mike. The phone rings. Mike picks up. Alex, in a panicked whisper, says, Mike, dude, you gotta help me. I got arrested. I'm in jail. Mike asks, what happened? And here it comes. The fatal mistake. Alex says, man, I'm so stupid. We were at Sarah's party. I had way too many beers. I knew I shouldn't have driven, but I thought I was fine. I totally blew the breathalyzer. Can you call my parents and help me figure out bail? What Alex doesn't realize is that he has just handed the prosecutor their entire case on a silver platter. He's just created Exhibit A for the prosecution. His own voice recorded in perfect digital clarity, confessing to every single element of the crime. He admitted to drinking. He admitted to drinking a lot. He admitted to knowing he shouldn't be driving. He admitted to operating the vehicle. His lawyer now has absolutely zero room to maneuver. There's no arguing that the breathalyzer was faulty. There's no arguing that he only had one drink with dinner. The jury will hear that phone call, and Alex's own words will convict him. That one call just turned a defensible case into an ironclad conviction. And it's not just for DUIs. It happens with every crime imaginable. Someone gets arrested for drug possession. They call their girlfriend and say, hey, listen to me very carefully. You need to go to the apartment and get rid of the stuff in the back of my closet. You know what I'm talking about. Flush it. Get it out of there. You haven't just confessed to possessing the drugs. You've now committed a brand new, often more serious felony, tampering with evidence. And you've implicated your girlfriend as an accomplice. Or maybe it's an assault case. You call your buddy and say, yo, make sure you tell Steve to keep his mouth shut. He better not talk to the cops about what he saw. Congratulations, you've just been recorded committing witness intimidation. That's another felony. The prosecutor will add that charge, and now they have even more leverage to pressure you into a plea deal. You see how this works? They give you the phone because they know that in a moment of panic, your human instinct is to reach out, to explain, to vent, to ask for help. And in doing so, you will almost certainly incriminate yourself. You'll try to explain what happened, minimizing your role, but in the process, you'll place yourself at the scene of the crime. You'll admit you were there. You'll admit you had an argument. You'll admit a key detail that only the person who did it would know. You're building the prosecutor's case for them, one panicked sentence at a time. So what are you supposed to do? This brings us to the immense value. The one piece of advice that can save you. When you are arrested and offered a phone call, there is only one person you should speak to. Not your mom, not your best friend, not your spouse. Your one and only call should be to a criminal defense lawyer. Why? Because of that one critical exception I mentioned, attorney-client privilege. The call between you and your attorney is legally privileged and confidential. It is the one call they cannot legally record or use against you. It is a sacred, protected line of communication. When you call a lawyer, you don't get a sympathetic ear to vent to. You get an expert who will give you two critical instructions. The first thing any good defense attorney will tell you is, stop talking. Do not speak to the police. Do not speak to your cellmates. Do not talk about your case to anyone but me. Invoke your right to remain silent. The second thing they'll do is start managing the situation. They'll speak to the police on your behalf. They'll start arranging for bail. They'll prevent you from making any more catastrophic mistakes. But what if I don't know a lawyer's number by heart? That is a huge problem for most people. If that's the case and you absolutely must call a family member, your script needs to be incredibly short and disciplined. It should be this and only this. Hi, it's me. I'm in jail at the name of precinct. I'm okay. I cannot talk about what happened. Please find me a criminal defense attorney right now. I will not speak to anyone until I talk to an attorney. I love you, goodbye. That's it. You don't say why you were arrested. You don't say you're sorry. You don't say you messed up. You provide your location and your single critical need, a lawyer. You give them a mission, not a confession. The one phone call myth is so dangerous because it frames the call as a right of release, a lifeline. The reality is that it's a tool of prosecution. It's an intelligence-gathering opportunity for the police, offered to you at your most vulnerable moment. Unless you're speaking to your lawyer, that phone is not your friend. It is a snake. So the phone call is a trap. But what about the other famous line from every cop show? The Miranda warning. You have the right to remain silent. Everyone thinks that if the cops mess this up, if they forget to read you your rights, you walk free. Case dismissed. A magical get-out-of-jail-free card. But what if I told you that in the vast majority of cases, a Miranda violation means almost nothing? That the police can and often do question people without reading them their rights, and that the evidence they get is still perfectly legal to use in court? The truth about your Miranda rights is far more complicated and far more dangerous than you've ever been led to believe. The Miranda warning, those famous words, "You have the right to remain silent," isn't a blanket protection that police have to give you the moment they suspect you of a crime. It's not triggered by an arrest. It's not triggered by being put in handcuffs. The police are only legally required to read you your Miranda rights when two very specific conditions are met at the same time. This is called the Miranda trigger. And the two parts of that trigger are custody and interrogation. Let's break that down because your freedom could literally depend on you understanding this. First, custody. Custody doesn't just mean you're under arrest. The legal standard is whether a reasonable person, in your situation, would feel free to terminate the encounter and leave. So, if you're sitting in the back of a locked police car, you're in custody. If you're in a small windowless interrogation room at the station with two detectives blocking the only door, you're in custody. But what if an officer pulls you over for speeding? You're not free to just drive away, right? That's a seizure under the Fourth Amendment, but for the purposes of Miranda, the Supreme Court has said that a routine traffic stop is generally not considered custody. The officer can ask you questions like, "Do you know why I pulled you over?" Or "Have you had anything to drink tonight?" All without reading you a single right. And your answers? They are 100% admissible in court. What if two detectives show up at your front door and say, "Hey, mind if we come in and ask a few questions about your neighbor?" You let them in. You're sitting on your own couch. You are absolutely not in custody. You can ask them to leave at any time. No Miranda warning is required. They can question you for hours, and every word you say can be used to build a case against you. Most people who incriminate themselves do it voluntarily, in situations just like this, long before the handcuffs ever come out. They think they're just having a conversation, clearing their name. But what they're really doing is handing the prosecution a rope. That's the first trigger, custody. But even if you are in custody, the police still don't have to read you your rights unless they plan on doing the second thing, interrogation. And this is where it gets even trickier. Interrogation isn't just a string of questions. The legal definition is much broader. It includes any words or actions on the part of the police that they should know are reasonably likely to elicit an incriminating response from the suspect. This is called the functional equivalent of a question. Let me tell you a true story that perfectly illustrates this. It's a famous case called Brewer versus Williams. A man named Robert Williams was suspected of murdering a 10-year-old girl in Des Moines, Iowa. He turned himself into police in a nearby city. His lawyer specifically told the police not to question him while they transported him back to Des Moines. The police agreed. So, Williams is in the back of the police car for the long drive. He's in custody, but the detectives don't ask him a single direct question. Instead, one detective, knowing that Williams was a deeply religious man, turns to him and begins what's now famously known as the Christian burial speech. He didn't ask, "Where's the body?" Instead, he said something like, "You know, with all this snow coming, it's going to be hard to find her. The parents are going to want to give their little girl a proper Christian burial. The very least we can do is find her so they can have some peace." He wasn't asking a question. He was making a statement. A carefully crafted, psychologically manipulative statement designed to play on Williams's faith and guilt. And it worked. Williams, overcome with emotion, led the detectives straight to the little girl's body. His lawyers later argued that this Christian burial speech was a form of interrogation, and since Williams hadn't been read his Miranda Rights, both his statements and the evidence of the body should be thrown out. The Supreme Court agreed. They ruled that the detective's speech was the functional equivalent of an interrogation, a tactic designed to provoke a confession. It was a violation of his rights. This case shows just how subtle interrogation can be. It's not always, "Where were you on the night of the 15th? Sometimes it's a quiet, calculated monologue in the back of a police car. So now you know the two triggers, custody and interrogation. But what happens if the police mess up? What if they have you in custody, they interrogate you but they forget or choose not to read you your rights? On TV, this is the magic moment. The slick lawyer stands up and says, "Your Honor, my client wasn't Mirandized. Case dismissed." The judge bangs the gavel, and the wrongly accused hero walks free. That is a complete and utter fantasy. In the real world, a Miranda violation almost never gets a case dismissed. The only thing that gets thrown out is the statement itself. The confession you make can't be used by the prosecutor in their main case against you. But that's it. And here's the really shocking part. What if, during that illegal interrogation, you tell the police where you hid the murder weapon? You say, okay, I did it. The gun is in the dumpster behind the 7-Eleven. Under a complex legal doctrine, your confession, "I did it," will be suppressed. But the gun they find in the dumpster? In many situations, the Supreme Court has ruled that physical evidence discovered as a result of an un-Mirandized statement can still be used against you. Let me repeat that because it's terrifying. They illegally question you, you confess and tell them where the evidence is, your confession gets thrown out, but the evidence itself, the gun, the stolen goods, the bloody knife, can still be presented to the jury. The case doesn't get dismissed. In fact, it might have just gotten a lot stronger, all thanks to your illegal confession. And the exceptions don't stop there. There's something called the public safety exception. This came from a case called New York versus Quarles. Police chased a suspect into a supermarket. They believed he had a gun, but when they caught him, his holster was empty. Before reading him his Miranda rights, an officer handcuffed him and asked, "Where's the gun?" The suspect nodded toward some empty cartons and said, "The gun is over there." The Supreme Court said this was perfectly fine. They created an exception to Miranda, ruling that when public safety is at immediate risk, like a loaded gun lying around in a public supermarket, police can ask questions to neutralize that threat before they have to read the suspect their rights. So let's put this all together. Police can question you before you're in custody without Miranda. They can avoid interrogating you even while you're in custody to avoid Miranda. They can violate your Miranda rights, and it won't get your case dismissed. In fact, it might even lead them to physical evidence they can use against you. And they can ignore Miranda entirely if they believe public safety is at stake. Suddenly, that right to remain silent you thought was an iron shield looks more like Swiss cheese. But the single most dangerous misconception is believing your silence can't be used against you. In 2013, the Supreme Court decided a case called Salinas versus Texas. A man named Salinas voluntarily went to the police station to answer questions about a murder. He wasn't in custody. He wasn't under arrest. He answered most of the questions freely. But then, an officer asked him if his shotgun would match the shell casings found at the scene. Salinas didn't answer. He just sat there. He shuffled his feet, he tensed up, he looked down. He remained silent. At his trial, the prosecutor told the jury that his silence in that moment was evidence of his guilt. An innocent person would have said, "No, of course not." But Salinas said nothing. The case went all the way to the Supreme Court, and they ruled that because Salinas was not in custody and had not explicitly stated that he was invoking his Fifth Amendment right to silence, the prosecutor was allowed to use his silence against him as evidence of guilt. Read that again. Your silence before you are arrested can be used as evidence against you unless you say the magic words. You have to speak up to claim your right to be silent. You have to say out loud, "I am invoking my right to remain silent," or "I am exercising my Fifth Amendment privilege." You can't just stay quiet and assume you're protected. You have to claim it. The ultimate takeaway is this. The Miranda warning is not a gift the police give you. It is a right you must claim. The only words you should ever say to the police when you are being investigated for a crime are these: "I am going to remain silent. I would like a lawyer." You say it and then you stop talking. Because anything you say, any gesture you make, any silence you keep, can and will be twisted, analyzed, and used to build a cage around you. And speaking of lawyers, the idea that you're automatically given a phone call and a high-powered attorney the second you ask for one is another Hollywood fantasy that gets innocent people into serious trouble. What really happens when you ask for a lawyer is something else entirely. And this is where we arrive at our third major misconception, one that stems directly from those TV dramas: the idea that asking for a lawyer is like pulling a magic lever that stops the entire machine. The myth is that the moment you utter the words, "I want a lawyer," the interrogation lights dim, the detectives sigh in defeat, and a helpful officer immediately hands you a phone book and a private line to the best defense attorney in the city. The reality is far less cinematic and infinitely more dangerous if you don't understand the rules. When you are in custody and being interrogated, invoking your right to counsel does one thing, and one thing only. It requires the police to stop questioning you. That's it. That is the incredible power of the Fifth and Sixth Amendments. It is a full stop. A brick wall. It is your constitutional right to end the interrogation. But notice what I didn't say. I didn't say they have to stop arresting you. I didn't say they have to stop the booking process or stop fingerprinting you or stop taking your mugshot. And most critically, I didn't say they have to get you a lawyer right there and then. That famous line from the Miranda warning, "You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you," is one of the most misunderstood sentences in American law. The appointment of that lawyer doesn't happen in the interrogation room. It doesn't happen an hour later. It typically happens at your first court appearance, called an arraignment, which could be 24, 48, or even 72 hours later, depending on the day of the week and the jurisdiction. For those 2 or 3 days, you are in a legal limbo. You are in jail. You have asked for a lawyer so they can't question you about the crime. But you don't have a lawyer yet. The police investigation, meanwhile, is still running at full steam. They are out interviewing other witnesses, executing search warrants on your home or your car, collecting evidence and building their case against you, all while you sit in a cell waiting for a lawyer you haven't even met. The pressure doesn't stop, it just changes. The detective who was just trying to be your best friend might walk by your cell and say something like, "Hey, your buddy from the car is in the next room," and his story is a little different than what we think you're gonna say. We're giving him a chance to help himself. The offer's still on the table for you, but it expires in an hour. This isn't technically questioning you about the crime. It's a statement. But it's designed to make you panic, to make you reconsider your silence, to make you knock on that door and say, "Wait, I want to talk." And the second you do that, you have reinitiated contact and waived the very right you just invoked. This is a game and you need to know the rules. The most important rule is how you actually ask for the lawyer. It has to be clear and unambiguous. The Supreme Court has ruled on this, saying, "Maybe I should talk to a lawyer" is not enough. Asking, "Do you think I need an attorney?" is not enough. Those are questions. They are seen as equivocal. An officer can legally respond to "Maybe I should talk to a lawyer" by saying, "I can't tell you that. But if you're innocent, why would you need one? Only guilty people need lawyers. Why don't you just clear this up?" And just like that, they've turned your constitutional shield into a weapon of guilt against you, and the interrogation continues. The magic words are not a question. They are a statement, a demand. "I am going to remain silent. I want a lawyer." That's it. You say it once clearly and calmly, and then the hardest part, you shut up. You say nothing else. They might try to engage you in small talk. They might ask you what you think of the local sports team. They might offer you a soda. You say nothing, because they are waiting for you to open the door they are no longer allowed to open themselves. Now, what about that famous one phone call? This is another piece of Hollywood fiction that gets people in trouble. The one phone call is not a constitutional right. It's not guaranteed by federal law. Most states have laws or policies that allow a person under arrest to make a call, but the rules are strict. It's usually to let a family member know where you are, or to begin the process of arranging for a bail bondsman. It is not a private, lengthy strategy session with your future lawyer. In fact, you should assume that every single word you say on that phone call, unless you are speaking to an attorney you have already retained, is being recorded and will be used against you. People have been convicted based on what they said on their one phone call. They call their mom or their friend and say, "Hey, I messed up, I'm in jail." And that vague admission, "I messed up," becomes Exhibit A in their trial. Let's put this all together in a real-world scenario. Imagine a young man, let's call him Kevin, is arrested under suspicion of theft. He's innocent. He was just in the area. In the interrogation room, the police are pressing him hard. He gets scared. He remembers watching a TV show and says, "I think I want a lawyer." The detective leans forward. "You think you want one? Or you want one? Because if you want one, that's fine, but it means you're not going home tonight. We'll have to book you, you'll sit in a cell all weekend, and you'll see a judge on Monday. Or you can just tell us where you were, we can check your story, and you can be home in an hour. Your choice." Faced with that, what does Kevin do? He wants to go home. He's innocent. So he talks. He tries to explain his alibi, but he's nervous. He gets a minor detail wrong. He says he was at the corner of 5th and Main at 10 p.m., but his phone's GPS data, which they later get a warrant for, shows he was actually at 7th and Main. To him, it's a meaningless mistake made under stress. To the prosecutor, it's a lie. It's proof of consciousness of guilt. He didn't ask for a lawyer unequivocally. He took the bait. And now his own words, his own attempt to prove his innocence, have become the primary evidence against him. The takeaway here is not that police are evil. They are doing a job, and that job is to close cases. They are legally allowed to use persuasion, tactics, and even deception to get a confession. Your only defense is not to play the game. You stop the game by saying, "I want a lawyer," and then you wait. The wait will be long. It will be stressful. It will be uncomfortable. But that discomfort is infinitely better than the life-altering pain of accidentally talking your innocent self into a prison sentence. So you've invoked your right to a lawyer, you've stayed silent, and you've finally been appointed a public defender at your arraignment. You breathe a sigh of relief thinking, "Okay, I'm innocent. The truth will come out now. The system will protect me." This belief, this fundamental faith that the truth is an automatic defense shield, is perhaps the single most dangerous misconception of them all. It's the idea that innocence itself is enough to save you. But the reality of our adversarial legal system is that the truth is often irrelevant. What matters is what can be proven, and more importantly, what can be believed by 12 strangers in a box. This brings us to misconception number 2, the belief that the truth will set you free. We are raised on this idea. It's the moral of 1,000 fables and the climax of 100 courtroom dramas. An innocent person wrongly accused takes the stand, tells their simple, honest story, and the power of their truth shatters the prosecution's case. The jury sees the light, justice is served, and the credits roll. That is a fantasy, a dangerous one. To understand why, you have to understand that a criminal trial is not a scientific inquiry designed to find objective truth. It's an adversarial contest. Think of it less like a laboratory and more like a boxing ring. On one side, you have the prosecution representing the state. They have a single goal: to prove guilt beyond a reasonable doubt. On the other side is the defense with their goal: to show that the prosecution has failed to meet that burden. The referee is the judge, who enforces the rules. And the jury? They're the ringside judges, scoring the fight based only on the punches they are allowed to see. They don't know what happened in training. They don't know what happened outside the ring. They only know what happens under the bright lights within the ropes, and according to the rules of the sport. The truth is not evidence. Evidence is what is used to try and prove the truth. But evidence can be flawed, misinterpreted, or outright misleading. And sometimes the actual truth never even makes it into the courtroom. Let me tell you a story about a man we'll call David. David is a 28-year-old graphic designer. He's a good guy, works from home, has a small circle of friends, and has never been in trouble with the law. One Tuesday night, a convenience store a few blocks from his apartment is robbed at gunpoint. The cashier, terrified, gives the police a description of the robber. A white male, late 20s, medium build, wearing a dark hoodie and jeans. A description that fits tens of thousands of men in that city alone, including David. A week later, police are canvassing the neighborhood. They knock on David's door. He's cooperative because why wouldn't he be? He has nothing to hide. They ask him where he was on the night of the robbery. David thinks back. Tuesday? Oh, that was my deadline night. I was home all night working. I ordered a pizza around 9 p.m. The police thank him and leave. David thinks nothing of it. But the detectives are building a case. The robbery happened at 9:15 p.m. They check the pizza place. Their records show David's order was placed at 8:40 p.m. and delivered at 9:05 p.m. A minor discrepancy. A simple mistake in memory. But to a detective with tunnel vision, it's not a mistake. It's a crack in his story. It's a lie. Why would an innocent man lie about the time he ordered pizza? Now they have a reason to dig deeper. They put together a photo lineup. It's a grid of 6 pictures. 5 are random fillers. 1 is David's driver's license photo. They bring in the cashier. The cashier is trying their best to be helpful. They stare at the photos. The human brain is a funny thing. It seeks to find patterns to make a match. The cashier's memory of the robber is a blur of stress and fear. But David's face, it has a similar jawline. The eyes are maybe the same. Under the immense pressure to identify the person who terrified them, and with the subtle unintentional cues from the detectives, they point. I think that's him. Number 4. In the police report, I think that's him becomes a positive identification. David is arrested. He is in shock. He keeps saying, "This is a mistake. I'm innocent. I was at home." He believes the system will sort this out. He believes in the truth. He waives his right to remain silent and agrees to be interrogated without a lawyer, because he thinks that's what an innocent person does. He wants to help them understand. In the interrogation room, the detectives press him on the pizza time. "David, you told us you ordered pizza at 9. The records say 8:40. Why did you lie to us?" David is flustered. "I don't know, I just misremembered. I was working, I wasn't watching the clock." But the more he explains, the more it sounds like he's making excuses. The more he talks, the more small, insignificant details he gets slightly wrong. His truthful, panic statements are being recorded, and they will be edited, taken out of context, and presented to a jury as a series of calculated lies. Now let's go to trial. The prosecutor stands before the jury. They don't have a weapon. They don't have fingerprints. They don't have DNA. But they have a story. They have an eyewitness, the cashier, who now, months later, is more confident in their memory. On the stand, they point at David and say, "That's the man who robbed me." It's powerful. It's emotional. Then, the prosecutor plays snippets of David's interrogation. They show the jury how David lied about the pizza, how his story changed. They paint a picture of a guilty man trying to cover his tracks. David's defense attorney, a public defender juggling 200 other cases, does their best. They try to explain the unreliability of eyewitness testimony. They put David on the stand. He tells the truth. "I was at home. I was working on a project. I ordered a pizza." But he's nervous. Who wouldn't be? His life is on the line. To the jury, his nervousness doesn't look like the fear of an innocent man. It looks like the anxiety of a liar. His simple truth now sounds hollow compared to the prosecutor's dramatic, evidence-backed narrative. The jury goes to deliberate. They don't know the objective truth. They weren't there that night. They only know what was presented in court. They have a tearful, confident eyewitness. They have a police interrogation where the defendant seemed to be lying. And they have the defendant himself, who seemed nervous and couldn't keep his story straight. The prosecution's story is a neat, tidy box. The defense's story is full of maybes and what-ifs. The jury is instructed to find guilt if there is no reasonable doubt. Is it reasonable to doubt the cashier's positive ID? Is it reasonable to think the police got it all wrong? For many jurors, the answer is no. David is found guilty. His truth did not set him free. In fact, his faith in the power of his own truth is what damned him. If he had said nothing, if he had invoked his Fifth Amendment right and immediately asked for a lawyer, the prosecution's case would have been just one thing: a shaky eyewitness ID. There would be no lies about pizza, no out-of-context statements to play for the jury. The prosecutor's story would have a giant hole in it. There may have been enough reasonable doubt for an acquittal. The system is not designed to divine truth from the ether. It's a system of procedure, rules, and persuasion. Your innocence is a fact, but it is not a legal shield. The shield is the Constitution. The shield is your right to remain silent. The shield is a competent lawyer who knows how to navigate the boxing ring, who knows how to challenge the other side's story, and how to tell yours in a way the judges will understand. Believing that your innocence alone will protect you is like walking into that boxing ring with no training, no gloves, and no coach, simply believing that because you are the good guy, you can't possibly lose. But the punches are real, and they don't care about your intentions. And this leads to a critical question. If the trial isn't really a search for the truth, and the system is this fraught with human error and procedural traps, how do most criminal cases actually get resolved? The answer flies in the face of every TV show you've ever seen, where a brilliant lawyer delivers a stunning closing argument to a captivated jury. The reality is far less cinematic and far more common. It's a process that happens not in a majestic courtroom, but in a quiet office, and it brings us to our third major misconception, the very nature of how justice is done. And this brings us to the third, and perhaps the most pervasive misconception about American criminal law. Misconception number 3: justice means a trial by jury. We see it in 1,000 movies. The determined defense attorney, the ruthless prosecutor, 12 ordinary citizens in the jury box, holding a defendant's fate in their hands. The dramatic reveal of evidence, the surprise witness, the passionate closing argument that sways the room. This is our cultural image of justice. The trial is the crucible where truth is forged. But this image, this cornerstone of our legal consciousness, is almost a complete fantasy. The staggering, almost unbelievable reality is this. In the United States, over 97% of all federal criminal cases, and around 95% of all state criminal cases, end without a trial. They don't end with a not guilty verdict from a jury. They don't end with a guilty verdict after a long, hard-fought battle in court. They end quietly in an office with a signature on a piece of paper. They end with a plea bargain. Think about that number. For every 100 people charged with a crime, only 3 to 5 of them will ever have their day in court, will ever have a jury of their peers decide their fate. The other 95 to 97 people will have their case resolved through a negotiation. The criminal justice system isn't a gladiator's arena. It's a marketplace. And the primary currency is guilt. So what is a plea bargain? At its simplest, it's a deal. The prosecutor, who represents the government, offers the defendant a chance to plead guilty to a lesser charge, or to the original charge in exchange for a lighter sentence. In return, the defendant gives up their constitutional right to a trial. It's an exchange, certainty for a chance. Now, why would a system built on the bedrock principle of innocent until proven guilty rely so heavily on a process that bypasses the trial altogether? The answer is a grimly practical one: volume. The American justice system is catastrophically overloaded. Prosecutors have hundreds, sometimes thousands of cases on their desks. There are not enough judges, not enough courtrooms, and not enough hours in the day to take every single case to trial. If every person arrested for a DUI, for shoplifting, for drug possession, for assault, demanded their constitutional right to a jury trial, the entire system would collapse under its own weight within weeks. It would be like trying to land every plane in the sky at a single airport at the same time. Chaos, gridlock, total system failure. Plea bargaining is the pressure valve that keeps the machine from exploding. For a prosecutor, a plea deal is a guaranteed conviction. It's a win. It clears a case, saves the state immense time and money, and lets them focus their limited resources on the most serious, violent, or complex crimes. A trial, on the other hand, is a gamble. Juries are unpredictable. Evidence can be suppressed. Witnesses can be unreliable. No matter how strong their case seems, there's always a chance they could lose. A plea deal takes that risk off the table. From the perspective of a defendant who is actually guilty, the logic is also clear. It's a calculated decision to minimize the damage. Why risk a 20-year sentence at trial when you can take a guaranteed 5-year sentence in a plea deal? It's a bitter pill to swallow, but it's a rational choice in an irrational situation. But here is where the concept of justice begins to fray and unravel. What about the people who are innocent? Why on earth would an innocent person ever plead guilty to a crime they did not commit? Welcome to the darkest corner of the American justice system. The trial penalty. This is the unspoken threat that hangs over every single defendant. The penalty is the substantially harsher sentence a defendant is likely to receive if they reject a plea offer, go to trial, and are found guilty. The difference isn't small. It can be the difference between probation and prison, the difference between 5 years and 25 years. Imagine this. You're 22 years old. You were at a party, a fight broke out, and someone was seriously hurt. You know you didn't do it, but you were there. Your court-appointed lawyer, who has 15 minutes to talk to you before your hearing, tells you the prosecutor's case is shaky, but not impossible. The prosecutor offers you a deal. Plead guilty to a misdemeanor assault, and you'll get 2 years of probation. No jail time. You can go home today. But if you refuse the deal, they will charge you with felony aggravated assault. The lawyer tells you that if you go to trial and the jury doesn't believe you, the judge is bound by a mandatory minimum sentencing law. You will get, at a minimum, 10 years in prison. Not maybe. Not possibly. 10 years. What do? You're innocent. But can you risk it? Can you risk a decade of your life on the hope that 12 strangers will believe your story over the story of a few other people from the party who are trying to save their own skin? You have a public defender you just met. The state has a team of investigators and a seasoned prosecutor. The pressure is immense. Your family is begging you to take the deal. Just take the deal and come home. So you stand before the judge, swallow your pride, swallow the truth, and you say the word that will brand you a criminal for the rest of your life. Guilty. This is not a rare hypothetical. This happens every single day in courtrooms all across America. The National Registry of Exoneration shows that nearly 25% of all wrongfully convicted people who were later proven innocent had originally pleaded guilty. They were coerced not by a threat of violence but by the threat of the system itself. They were punished for asserting their constitutional right to a trial. This is the reality of our justice system. It is a system of managed risk, not a system of truth-finding. It prioritizes efficiency over accuracy. The backroom deal has replaced the public trial. The search for truth has been subcontracted out to a negotiation process where the leverage is almost entirely on one side. The scales of justice aren't just tipped, they're often bolted to the floor in favor of the prosecution. So when we watch our favorite legal drama and see the lawyers battling it out in a beautiful courtroom, we're not seeing a reflection of our justice system. We're seeing the 3%. We're seeing the exception, the rare, expensive, high-profile spectacle. The other 97% of justice is invisible. It's administrative. It's a conversation in a hallway. It's a defendant, often poor and terrified, being forced to make an impossible choice between a guaranteed injustice and the risk of a catastrophic one. The search for truth is often replaced by a negotiation of risk. But what happens when you do get to that trial? What happens when you are one of the few who finally gets to tell your side of the story? Well, that brings us to another powerful myth, one that sits at the very heart of the American legal system: your right to remain silent. We've all heard it 1,000 times in movies and on TV shows. A stoic detective leans over a table in a stark interrogation room and says, "You have the right to remain silent." It's a phrase so deeply ingrained in our culture that we can recite it by heart. But what we think it means, and what it actually means in the high-stakes reality of a criminal investigation, are two terrifyingly different things. The myth is that invoking this right, staying silent, is a tacit admission of guilt. It's the idea that if you're innocent, you have nothing to hide. You should want to talk, to explain, to clear your name. After all, only guilty people need to hide behind lawyers and constitutional protections, right? This belief is not just wrong. It is one of the single most dangerous misconceptions an innocent person can have. It's a trap, baited with our own intuition, and it has destroyed countless lives. To understand why, you have to first understand the environment you're in when you're speaking to law enforcement. It is not a neutral conversation. It's not a chat with a neighbor to clear up a misunderstanding. Police officers, especially detectives, are masters of interrogation. They are trained in psychological techniques designed for one primary purpose: to elicit information and, ultimately, a confession. They are legally allowed to lie to you. Let me repeat that because it's a point that shocks most people. Police can lie about evidence. They can tell you your fingerprints were found at the scene when they weren't. They can say your coworker already confessed and implicated you. Even if they haven't even spoken to your coworker, they can tell you they have you on video, that witnesses have identified you, that they have DNA. None of it has to be true. They are creating a psychological landscape where confession seems like the only logical or beneficial path. Now imagine you're innocent and you decide to talk. You think, I'll just tell them the truth and this will all be over. The problem is, human memory is not a perfect video recording. It's a messy, flawed, and reconstructive process. Under the immense stress of an interrogation, those flaws are magnified 100 times over. The detective asks where you were last Tuesday at 10 p.m. You were at home watching TV. What were you watching? He asks. You panic a little. You can't remember exactly. Was it a movie? A series? You say, I think I was watching that new action movie on Netflix. A week later, you're talking to your lawyer and you remember, oh wait, it wasn't a movie, it was the season finale of that crime drama. Congratulations. You have just handed the prosecutor a weapon. You didn't just make a mistake. In their narrative to the jury, you lied. You lied to police. And why do innocent people lie? They don't. You've now created a crack in your credibility, a seed of doubt, all because you tried to be helpful and your memory wasn't perfect. Every single word you say is being recorded, scrutinized, and compared against every other piece of information they find. A slight misstatement about a time, a name, or a location can be twisted into a prior inconsistent statement, a legal term for "we caught you in a lie." This isn't theoretical. It's a grim reality. Perhaps there is no more powerful and tragic illustration of this than the story of the exonerated five, formerly known as the Central Park Five. In 1989, 5 teenagers, 4 black, 1 Hispanic, were brought in for questioning about a brutal assault in New York Central Park. They were innocent. But over the course of 42 hours of combined interrogation, something happened. These kids, without parents, without lawyers, were subjected to a barrage of classic interrogation tactics. They were lied to, told that others had already confessed and pointed the finger at them. They were promised they could go home if they just told the police what they wanted to hear. They were worn down, exhausted, terrified, and confused. And one by one they broke. They gave false confessions, feeding details to the police that the police themselves were suggesting. Their confessions were full of inconsistencies and contradicted the physical evidence at the scene. But it didn't matter. The city had its culprits. The public was satisfied. These 5 boys were convicted and spent between 6 and 13 years in prison for a crime they did not commit, all because they talked. It wasn't until 2002 that the actual perpetrator, a convicted murderer and serial rapist, confessed, with his DNA matching the evidence from the scene. The 5 were finally exonerated, but their lives were irrevocably shattered. They weren't an anomaly. The Innocence Project reports that in about a quarter of all DNA exoneration cases, the innocent defendant made a false confession or incriminating statement. They talked. So why is this right so fundamental? The Fifth Amendment to the Constitution states that no person shall be compelled in any criminal case to be a witness against himself. This isn't a loophole for the guilty. It's a shield for the innocent. It exists precisely because the framers understood that the power of the state is immense and that an individual, especially under duress, can be tricked, coerced, or confused into damning themselves. The burden of proof in our system is entirely on the government. They have to prove your guilt beyond a reasonable doubt. You have to prove nothing. Staying silent isn't an admission of guilt. It is a formal declaration that you are forcing the state to do its job without your unwilling assistance. And the Supreme Court has backed this up. A prosecutor cannot stand up in front of a jury and say, if the defendant was innocent, why did he ask for a lawyer? Why didn't he talk to the police when they brought him in? He must be hiding something. That is a direct violation of your constitutional rights, and it can lead to a mistrial. But here is where it gets incredibly tricky, and where the value of knowing the law can literally save you. Most people think their right to silence is a blanket protection that's always active. It's not. In the 2013 Supreme Court case Salinas v. Texas, the court made a terrifyingly subtle distinction. They ruled that if you are speaking to police voluntarily, meaning you're not under arrest, you haven't been read your Miranda rights, you're just helping with their inquiries, your silence can be used against you. In that case, the police asked Salinas if his shotgun would match the shells found at a murder scene. He didn't answer. He just shuffled his feet and looked down. At trial, the prosecutor argued that his silence in that moment was evidence of his guilt, and the Supreme Court agreed. Their logic was that since he hadn't been arrested and hadn't explicitly invoked his Fifth Amendment right, his silence was just part of the overall conversation, a telling reaction, not a constitutional protection. This is a legal minefield. So what do you do? The answer is not to try and selectively answer questions. The answer is to be clear and unambiguous. The moment an interaction with law enforcement turns from a simple conversation to an inquiry about a crime, you have only one job. You must say the magic words. You must say out loud, "I am going to remain silent. I would like to speak to a lawyer." Once you have clearly invoked your right to silence and your right to counsel, the protection clicks into place. The interrogation is supposed to stop, and your subsequent silence cannot be used as evidence of guilt. You have to open your mouth once to say you are closing it. It's a paradox, but it is the key that unlocks one of the most vital protections you have. The smartest, safest, and most effective thing an innocent person can do when faced with a police interrogation is not to try and talk their way out of it, but to say nothing at all. Because anything you say can and will be used against you, but your silence, when properly invoked, cannot. And that brings us to the person whose job it is to speak for you, your lawyer. The perception of defense attorneys is another area riddled with myths, starting with the biggest one of all, that they are just there to help guilty people get off on a technicality. This image is burned into our collective consciousness. The slick, morally bankrupt lawyer in a $1,000 suit, finding a microscopic loophole to let a monster walk free. They are portrayed as the antithesis of justice, a necessary evil at best, and an enemy of the people at worst. But this perception fundamentally misunderstands not just the role of a defense attorney, but the very foundation of the American legal system. The first thing you have to understand is this. A defense attorney's primary job is not to prove their client is innocent. Let me say that again. Their job is not to prove innocence. Their job is to hold the government to its burden of proof. It is to ensure that the state, with all its power, all its resources, all its investigators and experts, proves its case against a citizen beyond a reasonable doubt. This isn't some clever legal trick. It is the bedrock of our liberty. The Founding Fathers were intimately familiar with the tyranny of a state that could accuse, convict, and punish its citizens at will. They saw kings and governments throw people in dungeons on a whim, based on flimsy evidence or political motivation. So they designed a system to be a shield. They enshrined the Sixth Amendment in the Bill of Rights, the right to the assistance of counsel, as a non-negotiable check on the government's power. Imagine for a moment you are accused of a crime you didn't commit. The government has the police, the FBI, crime labs, and teams of experienced prosecutors all dedicated to one goal: convicting you. What do you have? You have yourself. You have your fear, your confusion, and your limited knowledge of an incredibly complex legal system. The defense attorney is the equalizer. They are the one person in the entire system whose sole undivided loyalty is to you and your rights. Now let's talk about that dirty word, technicality. When we hear that a case was dismissed on a technicality, the implication is that a guilty person cheated the system. But what are these so-called technicalities? More often than not, they are our constitutional rights. Let's say the police, convinced of a suspect's guilt, kick down their door without a warrant and find incriminating evidence. The defense attorney files a motion to suppress that evidence, and the judge agrees. The evidence is thrown out. The public is outraged. He got off on a technicality. But that technicality is the Fourth Amendment, which protects every single one of us from unreasonable searches and seizures. It's the right to privacy in our own homes. The reason that evidence is excluded is not to reward the guilty. It's to deter the police from kicking down your door, or my door, without a warrant. It's a message from the courts to the government that says, we don't care how certain you are. You must follow the rules. The process matters. If we allow the government to break the rules for people we think are guilty, we give them permission to break the rules for anyone. That technicality is the firewall that protects the innocent from a police state. Consider the true story of Clarence Earl Gideon, a poor drifter in Florida who in 1961 was accused of breaking into a pool hall. He couldn't afford a lawyer and asked the judge to appoint one for him. The judge refused, saying Florida law only required that for capital offenses. Gideon was forced to represent himself. He did a terrible job. He was convicted and sentenced to 5 years in prison. From his prison cell, with a pencil and prison stationery, Gideon handwrote an appeal to the United States Supreme Court. He argued that his Sixth Amendment right to counsel had been violated. The Supreme Court agreed. In the landmark case Gideon v. Wainwright, the court ruled that the right to an attorney was a fundamental right, essential for a fair trial, and must be provided to any defendant who cannot afford one. Gideon got a new trial, this time with a lawyer. His new lawyer did what Gideon couldn't. He cross-examined the key witness, revealing major inconsistencies in his story. He found other witnesses who provided an alibi. The jury deliberated for just 1 hour before finding Clarence Gideon not guilty. He was an innocent man who would have rotted in prison because he didn't have a lawyer to defend him. The system failed, and it took a constitutional showdown to fix it. This is the true purpose of a defense attorney. They are the system's quality control. They are the designated skeptic whose job is to test every piece of evidence, question every witness, and challenge every assertion the government makes. But what about the hard question? What about the client who the lawyer knows is guilty? The one who confessed to them in private? How can they possibly stand up in court and defend that person? This is where the oath and the ethics of the profession come in. The lawyer's duty is to the law and to the system itself. They cannot lie to the court. They cannot knowingly put on a witness who will commit perjury. But what they can do and what they must do is ensure that even that guilty person receives a fair trial. Why? Because the principle is more important than any single case. If we say, this person is guilty, so they don't deserve a vigorous defense, we've destroyed the very idea of innocent until proven guilty. The defense lawyer for a guilty client is defending the rights of everyone. They are ensuring the police didn't coerce that confession. They are ensuring the evidence was collected legally. They are ensuring the prosecution can actually prove its case to the high standard the law demands. Think of it like a stress test for a bridge. An engineer doesn't just test the parts of the bridge they think are strong. They test every weld, every bolt, every cable to its breaking point. The defense attorney is that engineer. They are stress testing the prosecution's case. If the case is built on a solid foundation of legally obtained, credible evidence, it will hold up. If it's built on shoddy police work, constitutional violations, or flimsy testimony, it's the defense attorney's job to make it crumble. Not because they love crime, but because we, as a society, cannot afford to build our justice system on faulty materials. Furthermore, a win for a defense attorney doesn't always mean an acquittal. In the vast majority of criminal cases that don't go to trial, a win is negotiating a plea bargain to a lesser charge that more accurately reflects what happened. It's arguing for a fair sentence that focuses on rehabilitation instead of just punishment. It's making sure that the human being they represent, regardless of what they did, is treated with dignity, and that their story is heard by the court. Their role is to be the voice for the accused against the most powerful entity in the land, the government. They advocate, they challenge, and they question. They force the system to be honest. Without them, the presumption of innocence is a hollow phrase, and the courtroom is not a forum for justice, but merely a stage for the administration of power. So the next time you see a lawyer defending someone you believe is guilty, remember, they aren't just defending that one person. They are defending a principle that protects us all. They are standing in the gap, testing the chains, and ensuring that when the state comes to take away a person's liberty, it has followed every single rule to the letter. This intense focus on rules and procedure is what makes a trial so different from what we see in the movies. The lawyer isn't just a performer. They are a technician. And the place where they perform their work, the courtroom, isn't a stage for dramatic confessions. It's a highly controlled environment, governed by complex rules of evidence. This brings us to another huge misconception, this one about the trial itself and the dramatic last-minute evidence that always seems to win the day. The reality of what can and cannot be shown to a jury is one of the most misunderstood aspects of the entire legal process. This brings us to our number one most pervasive, most Hollywood-fueled misconception about the American criminal justice system, the idea that any piece of information, any shocking revelation, can be thrown at a jury at the last second to win the case. You've seen it 1,000 times. The defense attorney is cross-examining a witness who's been cool and confident. Suddenly, the lawyer pulls out a hidden letter, a surprise photograph, or calls a witness no one knew existed. The prosecutor objects. Objection, Your Honor. The judge overrules. The evidence is revealed. The witness breaks down on the stand, confessing everything, and the defendant is dramatically exonerated. It's fantastic television. It is also almost complete fiction. The reality is that a courtroom is not a chaotic free-for-all where lawyers can pull rabbits out of hats. It is one of the most rigidly controlled environments you can imagine, governed by a dense, complex set of rules designed for one primary purpose: to ensure a fair trial by filtering out unreliable, irrelevant, and unfairly prejudicial information. These are the rules of evidence, and they exist because we, as a society, have decided that a person's freedom should not be decided by rumors, gossip, or emotional manipulation. It should be decided by solid, reliable, and relevant facts. Let's start with that first filter: relevance. Evidence must be relevant to the case at hand. It has to make a fact that is important to the case more or less probable. This sounds obvious, but it's a powerful gatekeeper. Let's say a man is on trial for tax evasion. The prosecutor can't bring in a witness to testify that the defendant cheated on his wife 10 years ago. Is it bad? Yes. Does it make him look like a bad person? Absolutely. But does it have any logical tendency to prove he knowingly underreported his income to the IRS? No. It's irrelevant. The only purpose of introducing it would be to make the jury dislike the defendant, to poison their minds and make them think, well, he's a bad guy, so he's probably a tax cheat, too. The rules of evidence exist specifically to prevent that kind of character assassination. Now for the big one, the one every law student spends weeks trying to master: hearsay. You've heard lawyers shout, "Objection! Hearsay!" on TV, but what does it actually mean? The simple definition is an out-of-court statement offered in court to prove that the statement itself was true. Sounds complicated, but let's break it down with an example. Imagine a witness, Sarah, is on the stand in a robbery trial. The prosecutor asks, "What did your friend Mark tell you?" Sarah replies, "Mark told me he saw the defendant, John, running from the bank with a bag of money." That is classic hearsay. Mark's statement, "I saw John running from the bank," was made outside of court. And the prosecutor is using it to prove that John was, in fact, running from the bank. The judge would sustain the objection, and the jury would be instructed to disregard it. Why? Why can't the jury hear that? Because the entire American system of justice is built on the right to confront your accuser. The defense attorney can't cross-examine what Mark said. He can only cross-examine Sarah about what she heard. He can't ask Mark, "Where were you standing? How far away were you? Were you wearing your glasses? Don't you hold a grudge against John because he got the promotion you wanted?" The jury can't look Mark in the eye, judge his credibility, his body language, his demeanor. They're getting the information secondhand, filtered through someone else. The system demands that if the prosecution wants to use Mark's testimony, they need to put Mark himself on the stand, under oath, and let the defense have at him. Now there are dozens of exceptions to the hearsay rule. Dying declarations, excited utterances, business records. Each one born from a specific legal reason why that particular type of statement is considered inherently reliable. But the core principle remains: we don't convict people based on gossip, or what somebody else said somebody else saw. Perhaps the most important rule, and the one that most directly counters the Hollywood drama, is the balance between probative value and prejudicial effect. Probative value is just a fancy way of saying, how useful is this evidence in proving a fact? Prejudicial effect is the danger that the evidence will inflame the jury's emotions, biases, or prejudices, leading them to decide the case on an improper basis. Here's the ultimate example: a defendant's prior criminal record. Let's say a man is on trial for burglary. He was convicted of 3 other burglaries 15 years ago. Now that information is certainly relevant, right? It shows he has a tendency to commit this kind of crime. But its prejudicial effect is absolutely massive. If the jury hears about his past, there's a huge risk they'll just conclude, he's a burglar. He did it before, he must have done it this time, regardless of the actual evidence in the current case. They might convict him based on his past, not his present actions. Because that danger is so high, the rules generally forbid the prosecution from introducing a defendant's prior criminal history, just to show he has a propensity to commit crimes. It's a cornerstone of the presumption of innocence. You are on trial for this crime and this crime alone. All of these rules, relevance, hearsay, prejudice, are what make the surprise evidence trope a fantasy. But the real nail in that coffin is a pre-trial process called discovery. Long before a trial ever begins, both sides, the prosecution and the defense, are legally required to exchange almost all of the evidence they plan to use. The prosecution must turn over all police reports, witness statements, lab results, photos, videos, and a list of the witnesses they intend to call. The defense also has to disclose its witnesses and certain types of evidence, like alibis or expert reports. This process can take months. Lawyers on both sides will know exactly what cards the other side is holding. That shocking, case-winning photograph? The defense attorney saw it 6 months ago. That surprise witness? Her name was on a list exchanged before the trial date was even set. If a lawyer genuinely tried to introduce a critical piece of evidence that they deliberately hid from the other side, not only would the judge likely exclude the evidence, but that lawyer would face severe professional sanctions and potentially even have the case declared a mistrial. The goal of a trial is not to be a gotcha ambush. It's to be a structured, predictable search for the truth, where both sides have a fair opportunity to see the evidence and prepare their case. So, as we wrap up this journey through the fog of legal myths, let's recap the 5 major misconceptions we've dismantled. Number 5. The idea that the insanity plea is a common easy get-out-of-jail-free card, when in reality it's incredibly rare, brutally difficult to prove, and often leads to longer confinement. Number 4. The belief that Miranda rights are read in every arrest, when they're only required for a custodial interrogation, a specific circumstance many people never find themselves in. Number 3. The dangerous assumption that if you're innocent, you don't need a lawyer, a belief that ignores the complexity of the law and the immense power imbalance when an individual faces the state. Number 2. The critical misunderstanding that you are legally required to answer police questions, when your Fifth Amendment right to remain silent is one of the most powerful shields you possess. And finally, our number 1 misconception: the Hollywood-driven fantasy that a trial is an unpredictable drama of surprise evidence, when in fact it's a highly regulated, methodical process designed to filter out unreliable information and prevent ambushes through the rules of evidence and discovery. The gap between our television-shaped perception of criminal law and its complex, often messy reality is vast. It's a system built not by screenwriters looking for drama, but by generations of lawmakers and judges trying, however imperfectly, to balance the immense power of the state with the fundamental rights of the individual. It's not always elegant, and it's certainly not always dramatic, but understanding these truths, seeing past the myths to the principles underneath, isn't just a matter of legal trivia. It's about understanding the very framework that governs our freedom, our safety, and our society. It's about knowing your rights and, more importantly, knowing why you have them. Because in the end, the law isn't just for lawyers and judges. It's the invisible code that belongs to and is supposed to protect every single one of us.